Guys, all right. So I've got a court case here. You've probably seen it. I didn't want to do this one, but I'm kind of messing around with some software, and other people have covered this case, but I have a little bit of background information that other people didn't cover. So anyway, let's just jump into it.
Mr. Gillespie, when we were reviewing your documents, your order, I mean your motion, some of the cases weren't making sense.
By the way, I'm testing a watermark. Yeah, it says tooken.
Oh, goodness. I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to.
I did, Your Honor, and that was something that I wanted to bring up today. So that's part of the reason why I didn't file a reply, is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. So, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name.
I want to point out that the attorney, Luke Kennedy, points out that Mr. Gillespie was using AI. He knows that he was using AI. He knows that he was using GPT. I want to point it out because it comes back later.
Neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Sure. I'm pulling it up right now, Judge. Bear with me 1 sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as the Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Hold on.
Yeah, and for the rest of this hearing, Mr. Gillespie is probably frantically researching these cases.
1 second, I'm trying to actually pull up the case itself. Hold on. Okay, and also Roland v. Say. I don't know if I'm pronouncing that properly.
Judge isn't back yet, Tristan.
I'm back.
There we go.
Okay. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193. It's a 2008 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where I did.
As far as the citations go?
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name, or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Roland versus Say case right after that, 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company, I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. And that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again,
All right, so it's not looking good. First of all, he filed his responses or his motions citing either incorrect or irrelevant cases, except for the one case that was correct. It seems to benefit the defense more than it does his side, which in this case is the plaintiff. Then he's filing responses to motions within an hour. Now, from my experience, and it's very limited, usually responses are pretty close to the response deadline, which I'm sure it varies state to state or district to district, but about 7 days-ish, unless the judge says otherwise. And now Mr. Kennedy is basically saying, well, this is kind of a trend for this guy, I think.
I'm not trying to cast aspersion. I'm just telling you facts. So he's been suspended in Maryland, and part of that was for lack of candor.
Hold on, where is he?
Oh, and part of that value added thing I said I would mention, it's about the Maryland suspension. And then there's more.
It appears that he either dropped off the Zoom call or lost internet connection, Judge.
I think he's coming back on. Hold on, let me see.
Okay.
Yeah. Mr. Gillespie?
Sorry, I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr.
Please.
Gillespie, I'm a former
Yeah.
staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess Chat GPT or whatever the legal version of the AI research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a second generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than I'm happy to provide additional briefing copies of the cited cases.
It's not a good move, Tristan. He's basically just trying to double down on the cases he cited in the motion that they're talking about, which is not a good move for Tristan. They basically confirmed that it's garbage. They said it's garbage, and then they confirmed that it's garbage, and now he's trying to double down on it, where he should be I don't know what he should be. Apologetic, maybe? But he should be backtracking a little bit to some degree. At least I think. I don't know.
Whatever.
Oh, sorry. One other thing. Judge Tammy Hayward is by far one of my favorites. I think she's wonderful. I think she is fantastic. Imagine if Mr. Gillespie is dealing with a rougher personality, because she's soft and sweet, but she's very critical. She's frank enough to get her point across. And you'll see that more as you go. She's not yelling at the guy. But
Trust that Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if two lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Okay. Well, very good then. Should we? How would you propose we proceed?
Mr. Kennedy, this is also your client's case. Talk to me.
Yeah, Your Honor, I was mulling kind of what to do about it and what to ask for. And again, some of the stuff is going to relate to the summary judgment motion, which is not necessarily before you at this point in time. I would at least ask for my client's fees to be reimbursed for having to be here and respond to the motion or the response brief itself, which I don't have that number right in front of me, but I'm happy to supply an affidavit of what that is. Beyond that, I'm not sure if I don't want plaintiff herself to be penalized, so I just want to put that out there. I don't think she should be penalized because I don't necessarily think she has anything to do with this necessarily. It is more.
Well, the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court, and the contumacious behavior is written in written form before the court. So I would definitely, always back myself up and look again at the statutes before I make a decision, especially on a contempt. But I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that.
Understood.
All right. All right, so what we're gonna do is continue this hearing. We'll give you a date certain for the rest of the hearing. Mr. Kennedy, go ahead, and maybe by that time, the summary judgment motion will have caught up with the court. Mr. Kennedy, go ahead and present your request for attorney's fees and sanctions, and the court will consider that as well as any further action I have to take. But Mr. Gillespie, I just judges talk. And so if you practice in multiple jurisdictions, the word will spread. And so I just caution you to be mindful of that.
Thank you.
All right.
So, Your Honor, just to make sure I'm understanding, so we're just going to set another hearing where we'll take up the rest of this motion as well as probably the summary judgment. And I know plaintiff filed a motion to withdraw deemed admissions, from RFAs.
I got it. I reviewed it.
Okay, and I know that's not right, but either. We just want to take all that up at one time down the road.
Yes, please. And I'll set you all separately.
Okay.
Miss Powell, if you could just give me a date, maybe, some time out, and when we get the summary judgment motion, and then let's hear this case separate from any others.
Yes, ma'am.
All right, thank you.
May we be excused, Your Honor?
Yes, you may.
All right, thank you.
Thank you.
Thank you.
So yeah, again, the subtle approach, right? But she's not really holding anything back, except for maybe the contempt. There's certainly some judges that would find him in contempt. She basically is saying that I could find you in contempt. Certainly you're having sanctions. I'm definitely reporting this to the bar. And we're going to talk about the consequences of your actions at the next hearing. A lot happens between this hearing and the next, supposedly. I still can't find how much time has passed between this hearing and the next. They would lead me to believe it's about 2 months, which is significant for the case itself, as we'll hear next. And I'll withhold the information about the Maryland bar and the other information until about 3/4 of the way through the second hearing.
And Unified Medical. But essentially the case took a turn because at the last meeting, the attorney for Caston Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. And so the court made a record, assisted by the Mr. Kennedy, who's the attorney for the defendant, who had gone through and basically noted all of the instances where there were documents, where there were cases cited in the document, but they did not, were not actually cases under Georgia law to which the court could lean for legal authority. All right, so at that point, I informed Mr. Gillespie that I would be sending this information to the state bar, which I did. And I have not heard back from them other than that they have received the information and it is in process with the general counsel for the state bar. But I did tell Mr. Kennedy and Mr. Gillespie that we would reconvene to determine what sanctions, if any, the court would impose. All right, and so I have Ms. Middleton. Yes, ma'am.
Good afternoon, Your Honor. I represent Plaintiff Cruz. We filed an entry of appearance on December 31st I did I left counsel a voicemail this morning, and we do have plans to connect after this hearing.
All right. So, Mr. Kennedy, I did ask you for your suggestions for the any sanctions that the court might issue in this case. But I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct?
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor.
See that little head shake by Attorney Kennedy?
Certainly much more educated about the pitfalls and dangers and so forth, and clearly it's not sufficient to rely on large language models to, I guess, verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think
It's not the right thing to say. The Georgia Bar has nothing to do with this case relative to the sanctions that you're discussing. The Georgia Bar is kind of an added layer of punishment. They've been working on this case for a year. I don't know if it's a little over, a little bit under. But I think they're going to decide basically that entire year is a waste of time based on the crap that Mr. Gillespie is filing. So this is costing time, money for everybody, right? Well, maybe not Mr. Gillespie, at least so far. But Mr. Kennedy has to defend his client. He's got to read all these motions. He's got to research this case law, which leads him to nowhere. They have to keep showing up to court. He has to defend these motions every time. His client sitting back there, hey, have we resolved this case? Meanwhile, Mr. Gillespie also has a client, right? So this is a personal injury case. Mr. Kennedy represents a trucking company, and Mr. Gillespie is representing an individual that's supposedly was involved in an accident with with the trucking company. So his client's probably like, what's going on with my lawsuit? When do I get paid? Blah, blah, blah. So now you want them to wait for the Georgia Bar? It's not going to fly with anybody in this room. Probably not even Miss Middleton, who's, well, we'll find out why Miss Middleton is here.
it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay, Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary, because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston Cruz, because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, I mean, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
From Tristan's iPhone.
All right, don't know what that was.
Go ahead, sir.
Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's written documents submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing?
So I was saying he should not double down right there. And Mr. Kennedy even opened the door at the very beginning of the case saying, we've had cases such and such, used AI. Judge Tammy later pointing out the same thing more than once. And then he doubled down saying, well, I can provide you copies with the, quotes or the cases. Well, clearly everybody in the room knows it's basically bullshit. So Mr. Kennedy's mad right now, right? You had an opportunity to come clean and you doubled down. And you wasted everybody's time, and we're back here again, and we still haven't even talked about the actual case that I'm trying to defend my client on. And it's been almost a year. Well, at least now we know how much time has passed.
Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further, but I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say. And so That's Exhibit D to that motion. It's my affidavit of fees.
All right.
If I may add, Your Honor, we don't, we don't disagree with the procedural history of this case, but we would like to object to counsel's dismissal.
Wouldn't be my dismissal, it'd be the court's dismissal, but
Well, your suggestion of the dismissal.
Okay.
Dismissal. Okay. All right. Well, you say you're objecting. You got to give me some basis for your objection.
Yes, Your Honor. So the plaintiff here has terminated previous counsel. It's my understanding previous counsel has also been terminated from the firm as well. My basis on the objection would be that plaintiff had, no idea this was going on, and as such, shouldn't be prejudiced because of this. My goal would be to get this case back on track. It's my understanding there was a consent motion to discovery filed with discovery expiring, I believe, the first week in March. So we would want to be as diligent as possible and still maintaining that deadline and getting the case back on track.
I want to be mindful that the parties in this case are not the primary drivers when it comes to filing motions and attending to court processes. And so if I'm going to sanction in any case someone who's acting on behalf of the parties, if Ms. Caston Cruz is unaware that her attorney is filing fiction, it would be unnecessarily punitive to her. I get that the case has not moved in a manner that is expected. But civil cases tend to have issues with timing anyway. Civil cases can, there's no real expectation of how long a civil case is going to take. We hope for things to be done in a timely manner. We have a structure for how discovery should be conducted. We have a structure for how cases should proceed, but mere timeliness is not something that we can really, that's really a factor that we can guess about or know about from the outset. What I do have is a desire to make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing just to tell me that you relied on Chat GPT to tell you that Chat GPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like Chat GPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people. One of my friends uses it as, she says, like, it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still because.
She uses Chat GPT like her wife. GPT like her wife. It's actually very accurate. Let's just hope my wife's not in the room when I make the comment about that being accurate.
I am so old school that this is the phrase that keeps coming to my head: garbage in, garbage out. which we were all told when at the outset of, and I'm old enough to go back to when we switched from typewriters um, to personal computers and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case because I really feel like Ms. Caston Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law and statutes upon which the court can rely. And so, with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, it was $25,498.08. That's fees and costs.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am, and then we'll get it back to our to the
$25,000. So let's say that Mr. Gillespie was using AI like it was his wife. Shit, she's gonna throw something at me. And it happened to cost him $25,000. Sounds pretty accurate to me. Sorry. Oh man, I'm gonna be in trouble tonight. My wife's over there. Just kidding. Love you. Mr. Gillespie. Okay, so $25,000 sanction. Basically, Your Honor is fining you for every dollar that essentially Mr. Kennedy's client is or would have been responsible for up to this point. And she's basically saying that everything that we've done involving this case, it's just been irrelevant. Like we're kind of starting over. Now, the tricky part is going to be after this conversation relative to the actual case, because you just heard Judge Tammy say, I'm not inclined to grant the motion for dismissal because blah 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 plaintiff, right? And your client doesn't know this is going on. That's going to come up next. What we also heard was from Ms. Middleton is that Mr. Gillespie was fired from his law firm, and we also know that the law firm's not going to be responsible to pay for that sanction. His client's not going to be responsible to pay for that sanction. Just him. Tristan Gillespie, you're responsible for the $25,000 in sanctions. Now he can appeal this, and we'll see what happens. This is going to be a tough one to appeal. If he appeals it, I don't know what's going to happen. I'm assuming Mr. Kenny's going to come back with an itemized bill. They might reduce it a little bit, find some validity in something, but I don't know. Okay, so let's get you some information. Excuse me. So why was Mr. Gillespie suspended in Maryland? Well, I got a feeling it has something to do relative to similar practices, but it's not necessarily the same. All right. So in Maryland, I had it pulled up. This one comes from the Supreme Court of Maryland. Gillespie had filed complaints in over 600 Americans with Disabilities Act tester cases, misrepresenting his work hours and employment status in fee petitions and settlement negotiations. So he's overcharging people. And when I get down to it, it's going to say substantially, but I got a feeling it has something similar to do with what he was doing here. He's filing cases all over the country, 600, and I'm guessing he probably did something similar where he spent very little research time and response time using AI, and then he would charge inflated hours for work that he didn't actually do. Based on this, the Maryland board filed filed for four different or filed for it's like 4 to 6 different violations. They ended up suspending him for 6 months. Mr. Gillespie appealed this. He came back and they settled on, or they negotiated, or the Maryland Court of Appeals came down and changed the 6-month ruling, or the 6-month suspension down to 4 months. And then between the Maryland bar and Mr. Gillespie, they filed this with the Supreme Court of Michigan. The Supreme Court of Michigan basically said that no, this isn't good enough. The Supreme Court had issues with the 4-month suspension, stating the panel identified 2 main aggravating factors. Gillespie repeatedly filed default judgment motions nationwide, asserting hundreds of hours he did not work or intend to work to secure unearned attorney's fees. He also arranged numerous settlements for fees based on fictitious work with no intention of collecting from plaintiffs if cases did not settle. Gillespie also denied any wrongdoing, failed to acknowledge the seriousness of his conduct, defending the accuracy of his petitions, which we saw a lot of this, some of this at least, in this case, and pretended not to understand the breach of duties to his clients. So the Supreme Court of Maryland, they stuck with the 4-month suspension, but the difference is he would be required to apply for reinstatement. So essentially making the suspension indefinite, as opposed to a standard 4-month suspension where he would automatically be reinstated after 4 months. So Maryland is saying, all right, basically after 4 months, you're eligible to apply to be reinstated. Oh, testers. So he filed complaints in over 600 tester cases. I had to look this one up too, because it's like, what the heck is a tester? Basically, a tester, based on the work that he was doing, well, the Google definition, which is ironic that I'm using Google AI, Someone who simulates a customer interaction to evaluate a business operations compliance with the law, despite having no genuine intent to use the goods or services. In this case, his clients were people, I believe, that were booking hotel rooms online, and then they were turning around and filing complaints or lawsuits based on these venues not being ADA compliant. It sounds a little sketchy to me, but apparently it's legal. However, the question is not so much whether it's legal, but whether or not there's actual damages to sue for. So I had it up earlier, but from my research, the court is not completely consistent. The Supreme Court is basically undetermined, saying that it has to be decided at a lower level. This has gone up between 5 different circuits. 3 of the circuits basically say, no, there's no damages, there's no grounds to sue. 2 circuits have said, yes, you can sue. There are damages because these companies have violated ADA, or they have ADA violations, or they've violated the Americans with Disabilities Act. So I guess it just depends on where you're located on whether or not testing is a thing for you to do. I don't know. It sounds stupid, but apparently it's a pretty common business practice. And it's been one for a long, long time. So, all right, the special add-on part. Because of his suspension in Maryland, he's also now suspended in New York, and I don't think that came up until very recently. So he's suspended in New York. When I try to look up the reasons why, it's because he was suspended in Maryland. In New York, he's suspended for 12 months. I couldn't confirm whether or not it's definite or indefinite. I had it up yesterday, but I had to redo this whole recording. So I think it was indefinite, but either way, he's suspended in New York, and we'll see what happens in Georgia. I don't see any updates to a complaint filed in Georgia as of January 25th, 2025. Okay. Now, here's where I was going to stop the video because, well, after Mr. Gillespie responds and drops out. But the case is kind of relevant too, right? Because they've been doing these hearings for a year, but they haven't actually covered the case. Now, Mr. Kennedy has an open motion for dismissal. Miss Middleton is brand new to the case. Now, originally they make it seem like she's brand new, like Mr. Gillespie. Hey, Mr. Gillespie, you're fired. You're fired from this law firm. You don't get to keep this client. We're going to put this Middleton on this. By the way, Ms. Middleton, you have court tomorrow. But apparently that's not the case. Apparently Ms. Middleton has had a couple months, which doesn't really help their client. So let's just watch some more of the video, and my voice is kind of annoying anyway.
Insurance companies paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court, and in this case, so I'm not going to nitpick at this point. I feel like from the outset of the case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file. If you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that that is an excessive amount. So $25,498.08. That's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order, or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Ms. Middleton, you're just coming into the case. Can we get back on track with the merits of the case?
I believe so, Your Honor. In all honesty, I have not had a chance to really take a look at that motion for summary judgment. I did see some mentions of reopening default in the docket. If counsel's willing to get this back on track with discovery, I mean, we would have no reason to oppose that. And I'm happy to get on a call with counsel once this hearing wraps as well.
Here's my only issue, Judge. So I filed this motion for summary judgment because they didn't respond to requests for admission, right? So under OCGA and 1136, those are just deemed admitted. And the case law is very clear that to overcome those deemed admissions, they've got to provide credible, admissible evidence that would refute them. And there is none right now. I mean, they filed a reply brief that had an affidavit from their client that is inaccurate, and we can go through it if you want. I can show you exactly why. She's got, first of all, a different date of a motor vehicle collision, saying I was involved in a motor vehicle collision on January 4th, 2024 on I-20 in Douglas County, Georgia. And can I share my screen on here?
Your Honor, if I could be excused, I know a lot of this going forward doesn't pertain to me.
Yes, Mr. Gillespie, you may be excused. We'll get you in order.
Can you see my screen, Your Honor?
Mr. Gillespie.
Yes, sir.
Okay, this is the police report from our case. As you can see, I can try to
I have December 14th, 2023.
Right, in Gwinnett County, totally different day than in her affidavit, sworn affidavit that has been submitted to this court, which again is just kind of consistent with how things have gone, says that this is the day that she got in a motor vehicle accident and was injured. I mean, I don't know what to do at this point. That's all. The only evidence they have, apparently evidence in quotes, is this affidavit from plaintiff that says she was injured in a motor vehicle collision on a completely different day that she supposedly received medical treatment for. But then again, we've got these requests to admit that they're deemed admitted that basically say, my medical treatment wasn't caused by this accident and wasn't necessary, and those sorts of things that just completely defeat her case. So at this point, I'm not sure there's a lot to even argue on their side as to how they overcome a summary judgment motion. So that's why I was asking I know you're not inclined to dismiss it on just a pure sanctions ground under 915.14 or because of the contumacious conduct to the court, but I think I'm also entitled to you granting summary judgment in my favor.
All right, Ms. Middleton.
I mean, the fact that there's a police report showing that the wreck happened, I mean, obviously there's some meat there. I mean, we would obviously object and request for an additional 30 days to respond to the motion for summary judgment, if you would be inclined, Your Honor.
Well, kind of not, because at the point where I guess you came into the case, we had been dealing with the sanction issue, and that has been more than 30 days. So from that point, Mr. Gillespie and the firm and whoever he's dealing with had noticed that there was a pending motion that the court did not hear, and that there was time at that point to address that pending motion or to come up to speed on what that was. And at this point, the court's not inclined to continue to delay this issue. To Mr. Kennedy's point, if if the discovery is deemed admitted and we're dealing with the basis of, okay, these facts are a part of the record, then you have to come with the strongest evidence to show that the deemed admitted facts have that there is something to counter those facts that have been admitted by failure to respond to discovery. So just the fact that there are 2 police reports or 2 incidents of an accident, one in January of 2024 and one in December of 2023, the existence of those divergent things is one thing, but none of that is enough to overcome what has been admitted.
I'll also just point out that she also in the affidavit says that she was struck from the rear by a vehicle. And I can pull back up, but the police report from our case, she was backed into. So it's like a completely different mechanism of the way the accident happened too.
And, you know, given the procedural history of this case, Your Honor, I do think we have good cause to possibly withdraw or amend those omissions. You know, I would want to move to do that.
Well, that's already been done.
This is the issue that I'm having, though. Y'all have, I don't know how you got into the case, Ms. Middleton, and so I don't want to beat up on you too bad. But the issue is that y'all have had plenty of time, because since we had the first sanctions case, I know that was probably sometime in early October, or I feel like it was October.
August.
It was August, because I've gone to judicial training since then. I've come back. We've had the holidays. So since August, we've had a substantial amount of time for you to file whatever you wanted to file. Because had I decided to accept your filings, fine. They're already on the record. Let's deal with them. But I didn't restrict anybody from filing anything. The only thing I asked for at the point that we left in August was for information about the filings that involved Mr. Gillespie and the sanctions. I don't know when you came into the case, but there was plenty of time entering the case to file whatever was necessary to protect the rights of Ms. Caston Cruz. And so if you didn't make use of that time, there's not a lot I can do in this case.
Well, and Judge, I mean, they did file a response to my motion for summary judgment, and they did file a motion to amend or withdraw their deemed admissions. It's not like nothing's been briefed and been filed. I mean, this stuff was all briefed and is in front of you and was briefed back in September, in August, and October.
The issue is, though, that I don't have a lot of information that says we need to overturn the admissions and reopen that part of the case. And also, I'm kind of leery of what was filed, because it was filed by Mr. Gillespie. At this point, the court has no confidence in the validity, viability, or legal basis of anything that Mr. Gillespie files with this court.
So am I taking that as you're disregarding basically his response briefs and the pleadings, the briefs he's filed? And at this point,
unless I'm hearing argument from Ms. Middleton.
Again, Your Honor, we do not disagree with the procedural history of this case. We started the case on November 26th. We have been having difficulties getting the file. So, I do apologize if my knowledge of the case isn't exactly in alignment with the procedural history of the case. So I do want to be honest about that. But, again, we would want to move to withdraw and amend the admissions, based on the previous procedural history of this matter.
So when you came into the case, you came in relying on what Mr. Gillespie filed, and you didn't file your own or amend?
We did rely on the Felicetti firm, which was the firm that Mr. Gillespie worked for. I knew that he relied on ChatGPT for the filings, and I knew that that was an issue. But in terms of the admissions, I really wasn't aware of that.
The issue is, and I know you know this, Judge, so this isn't going to educate you, but the problem is for them to be able to withdraw and amend their admissions, they have to show that the admitted under InterSouth Properties versus Contractor Exchange, which is 199 Georgia App 726, the admitted request either can be refuted by admissible evidence having a modicum of credibility or is incredible on its face. And at this point, there is no evidence in front of you at all to refute the admissions. I mean, that's the problem.
No affidavits, no certified copies, no
medical record
filed with the, yeah.
There's just nothing. So there's one 5-paragraph affidavit that we've already shown is not even reliable. So I'm sympathetic with Ms. Milton. She's only been in the case for a couple months, but at the same time, you don't always inherit the best cases, I guess. It's just how it goes sometimes.
Well, and this is what I say. Knowing the procedural history of the case, at that point, if I'm coming into a case that is problematic, I would amend the filings. I would ask for leave of court if necessary, but I would definitely amend the filings that were already done to preserve the issue, but to amend them to perfect them such that by the time that we actually argued the case, then the amended filings would take care of whatever deficits were done before. There's nothing that prevents you from amending a pleading. There's nothing that prevents you from, if your response was done by the previous attorney, coming in and amending and updating that response or providing additional evidence that would support and give the court a basis for the decision to overturn the fact that the admissions have been deemed admitted.
So it sounds like Judge Tammy is trending toward allowing the continuance. And after looking at the time frame, so Taylor Middleton picked up the case on November 26th, holiday. So she had it all the way through December. Holidays. I know that's not an excuse, especially on behalf of the client. But it's realistic in the United States. And then this hearing, I believe, is somewhere in January 15th. January, I think it's January 15th. So she didn't have it for quite 2 months, and I'm sure it probably wasn't her main priority. But on the other side, there's plenty she could have done. And that's basically what Judge Tammy is trying to reiterate. So will she let this continuance, or will she approve of this continuance, or will she dismiss the case?
Or bringing evidence or witnesses to this hearing. There's a lot of ways to do it. But Your Honor, I think you could issue an order in such a way that it wouldn't extinguish any claim that the plaintiff may have, not against my clients, but if that's of concern.
Is this a first filing? It's not a refile?
To my knowledge, it's not a refile.
My knowledge as well, Your Honor.
Although, if I'm not mistaken, maybe I'm getting my cases mixed up. I think the complaint says it's a refile, but I was never aware of a first filing. I'm gonna look right now.
All right. Okay, so the court is going to make a decision in this case, and I will issue an order. Mr. Kennedy, if you will get me an order on the sanctions, I'll go ahead and sign that.
Okay.
All right, Ms. Middleton, the cases are what we get. You know, I was in civil practice too, so I understand that sometimes if you take over from another attorney, it kind of is what it is. But let me have some time to consider all of the you know, I'm not a superior court judge, so I can't balance the equities as it were, but I do have to consider you know, uh fairness, and balance those things that would affect each of the parties in this case. So, all right. Thank you, Mr. Kennedy. Thank you, Ms. Middleton. And we will get an order out to you.
Thank you, Your Honor. The only, before we go, if we could, and this may be something that I can work out with Ms. Middleton, I don't know, but we do have the motion to open the default as to liability and set aside the liability judgment as.
Yeah, I mean, we're not missing anything by the last couple seconds. Missing the last couple seconds of that. It sounds like there's a completely different law firm on there. Originally, I thought the firm that Mr. Gillespie was working for, they just passed it on to a different lawyer. But it sounds like he was fired from his law firm, but it's a different law firm taking over this case. I could be wrong. I don't know. I'm married, so I'm often wrong. Tell me what you think. When I recorded this last night, I did a better job. I had my information all lined up, and I was probably dressed better. I was less tired. But that's interesting. I mean, I know a couple people have covered it. Nobody's really described the background information of the Maryland sanctions or suspension. I've been trying to check while I'm making this video to see if anything has come of the Georgia bar. I don't see anything, but then again, this was, you know, 11 days ago, 10, 11 days ago. If you could, please hit the like button. Sharing these videos helps out enormously. I've got a PayPal, I think, if you want to contribute to the channel. 100% of the proceeds, as of right now, go back to the channel, unless otherwise specified. You know, I know sometimes you guys want me to get dog treats or kid presents, stuff like that. I'm typically live most days, most weekdays during the day, around 4 p.m. Eastern time. And you guys enjoy your night. And whatever else I forgot.